Okay, well, ETT1, I will see the court's going to do an order to show cause. I don't like to do those, but folks, you can't make an appearance in violation of the rule. Number 3, before I go through all the appearances with each of the parties, here's what the court needs to really ask a quick question. We do have a media request. We have a media request on Richt. From the court's perspective, this is a public courtroom. People are more than welcome to observe. Technically, I only have a media request, and I'm going to ask Mr. Falcone if he thinks something different. To my court's understanding, I think I just only have a media request on the Richt matter. But does anyone have an objection if they wish to record the other 3 matters? Actually, I'll do this one by one since I have different counsel on different ones. So when you all make your appearance on Hunwarsen, I'm just going to need to know if anyone has an objection when you make your appearance, because then I would need to address that. But Mr. Falcone, can you just confirm? I only show media request on one of the 4 cases. Is that correct, sir?
Alex here. I was not expecting to speak at this hearing, so I didn't set my this particular machine up to record my own voice. In any event, I can summarize my response to the court really quickly. I wanted to apologize for that alarm jingle that was picked up in recording. There's nothing I could do about it in editing, so you guys just kind of had to suffer through it. Anyway, District Court Judge Joanna Kishner had stacked up 4 hearings today. I was only aware of 2. One was the Hunwarsen case, and one was the Richt case. And the other 2 that I wasn't aware of were the King case and the Henry case. So we didn't have media requests in on the 2, the King and the Henry case. And so that's the concern that she had brought up. But it didn't end up being an issue because Judge Kishner invoked her ability under the rule to waive the permission requirement, and then she goes ahead and checks with all the attorneys to make sure that they don't have any objections, and none of them do. And so I was able to record these 4 hearings in the Real Water saga.
No worries. Okay, but if the process that I stated, does that work for you? I see one for Richt. I did not see one for my other 3 cases. But if I just hear if anybody has an objection, then we address that at the end of the appearances. Would that meet your needs? Okay, so let's get through appearances, and then so we're on Hunwarsen versus Affinity Lifestyles, which is 831543. So, counsel for plaintiff, please.
Good morning again, Your Honor. This is Brianna Switzler, bar number 15653, on behalf of plaintiff Hunwarsen Plaintiffs.
Thank you so very much. Okay, on behalf of Affinity, please.
Good morning, Your Honor. Joel Odou on behalf of AffinityLifestyles.com, Inc., doing business as Real Water, Tennessee, and I believe Brent Jones may be a third-party defendant in this case.
Okay, and your position on recording?
I represent all of those entities, Your Honor, including Mr. Jones, if he is a third-party defendant. And I'll refer to them all collectively as Real Water for ease of reference.
I appreciate it. And your position with regards to whether or not this matter could be recorded or not be recorded, because I have a media request. I'm aware of one. I don't see it on my other 3.
No objection, Your Honor.
No
you
objection.
Can record this case if he chooses.
Okay. Thank you so very much. Okay, let's continue on. I'm just going to do the orders that I've got. That on behalf of Nevada Beverage, please.
Good morning, Your Honor. Colt Dodrill, bar number 9000, on behalf of Nevada Beverage.
And your position on recording, please.
We have no objection.
And the date you filed your notice of remote appearance, or what pleading you put it on, please.
Filed it on October 14th in the Richt case and October 14th in the Hunwarsen case.
Right. Well, right now, I appreciate we're on Hunwarsen. Since remember these are each individually numbered cases that are only coordinated for discovery, I do need to have appearances each time I call these cases. So, although I have an idea at the end, but Nevada Beverage we took care of. So next is United Natural Food, please.
David Spurlock, Your Honor, on behalf of United Natural Foods, bar number 2565, and I have no objection to recording.
Okay, you're also on WFM Southern Nevada, is that correct?
Yes, Your Honor.
Same position?
Same position.
Thank you so much. Milwaukee Instruments.
Good morning, Your Honor. Elizabeth Lowell, bar number 8551 for Milwaukee Instruments, and I have no objection to a recording by Mr. Falcone.
The date you filed your notice of remote appearance?
We filed a notice of remote appearance on September 30th and again on October 17th.
Okay, because, right, it has to be on Hunwarsen for each particular hearing, right, under the Supreme Court rule. Do appreciate it. Thank you, Ms. Costco, please.
Good morning, Your Honor. Michael Federico on behalf of Costco. Dates of notice are August 29th and then October 12th after we got the change of date for this hearing, and we have no objection. Thank you.
Thank you so much. Okay, ETT1. No one?
I believe Mr. Kim is.
Well, that's what I thought. I'm calling it.
I don't see any.
We don't see anyone on behalf of ETT1. Has Mr. Kim decided to no longer be part of this?
There he is.
Okay. Would you like to make your appearance, sir? Okay, I'm going to circle back around to you so that we can get other people taken care of and come back. Thank you so much. Okay, I did Whole Foods, we did Affinity. We still have no attorney on Hanna Instruments, is that correct? If there is, I don't see anyone that checked in.
I'm sorry, Your Honor. Jason Wigg on behalf of Hanna Instruments. I believe I did check in.
Oh. Okay.
I may have. I checked in on two of the matters, Your Honor. I may have neglected to include this case number as well. If so, I apologize.
Okay. And counsel, your bar number and firm, please.
My bar number is 7953 Murchison and Cumming, and the notice of remote appearance was filed on October 13th, and I have no objection.
Appreciate it. Thank you. Just to let you know, on this case, yours is listed as no attorney, so it does not show that you've made an appearance on this case. That's down in the clerk's office, the Odyssey official record. So,
thank you, Your Honor.
You may want to get that taken care of. Okay.
I will.
They're taking care of the other. Circling back to ETT, did you get?
Good morning, Your Honor. Can you hear me now?
We can hear you now. Go ahead, please.
Great. Benjamin Kim, Pro Hoc Vice for ETT1. Notice of remote appearance was filed October 13, and no objections to the media request.
Thank you. And who's your local counsel?
It is Michael Melendez.
Which is where? I don't see him checked in. Supreme Court rule specifically requires all local counsel must be here for every single hearing.
I'll withdraw formal appearance and observe then, Your Honor.
Well, then are you not participating in any of the scheduling components on behalf of your client? That's what today is, so I'm getting you dates. I want to find out where your local counsel is, please. We'll circle back to you in just a moment. Straight from the rule, folks. Thank you so very much. Okay, Okay, I've got that. I don't think Special Master's on, but just in case, I'll ask to see. No, okay. Is there anybody who's not made an appearance on this case who wishes to make an appearance? On Hunwarsen. Okay. Now given another reason why I'm pausing for a quick second, because I'm trying to see if we're going to get local counsels required under the rules on ETT1. No. Okay, of course, going to have to consider whether it has to do an order to show cause for non-appearance. Supreme Court Rule 42, folks. So anyway, the court's going to evaluate that. So as you know, and this is going to apply to all four of the cases, but we'll deal with this one first, is for many of the parties, most everyone on this case was also on the right case. And so when we did the right case status check, it was the agreement of all the counsel who were present for that I continue and not do status checks immediately on the other three cases because you want an opportunity to speak with Special Master Hale, get CMOs or however you wish to phrase them, basically scheduling orders, CMOs, some proposal as to dates so that you all could coordinate among yourselves and so that you weren't getting basically trials overlapping one another. And that's what the minutes had stated. And then I was supposed to have gotten said proposed scheduling orders, CMOs, however you'd like to phrase them, before today's hearing. As you all know, I do not have any. So we needed, since we did not have any, and since the date had already passed, and I do appreciate that you all have been working and have deposited X thousands numbers of documents, where you've deposited X thousands numbers of documents, and I do appreciate you working on some different things, but remember the hearing that you all referenced to this court was back in September, which is why we gave you the additional 30 days to get us some kind of scheduling order, realizing that it's not only this department that has these cases in a coordinated basis, but there's other departments, so that you all really could kind of hopefully come up with some master schedule, how you wanted to do these trials, and then we could see if those were appropriate for this department's cases. But since I have none of that, I have to get you all schedules, because you can appreciate these cases are back from 2021, and the court's fully appreciative that they got removed, but we need to get you some dates here, folks, so that in accordance with the rules, these are set forward. So, since I've not received anything, and not received any status report or anything at all from you all, nor in this case have I received, well, I haven't. Bottom line is, the only thing that we show is I have a status of discovery that was provided on from Special Master, and that is all I currently have. So, at this juncture, we need to get you some dates, and we have a statement that counsel for plaintiffs represent that Hunwarsen, Richt, and King can be set for trial in 9 months. And counsel for defendants represent the case should be set for trial in 12 months. And I'll counsel for Henry. Well, I still have to set Henry. You might not have a specific date, but you still have to do it. And that was dated October 11th, which if you add 9 months to October 11th, or a year to October 11th, that puts you either, well, you all can do the math, right? Either put you October 2023 or put you around August 2023. So what this court's going to ask, and I'll start first with plaintiff, and then we'll circle around, is first, is there a preference on this case? Because if you look at case numbers, this is the lowest case number in Department 31, not the lowest case number overall, but the lowest case number in Department 31. So does that mean this case goes first in this department, and this is the case we should set sometime between August and October of 2023? Let's hear from Plaintiffs' Counsel, then we'll go to Affinity, then we'll go to anybody else who wishes to be heard.
Good morning again. Brianna Switzler on behalf of plaintiffs. It is plaintiff's position that since this is the lowest case number in this court, that the Hunwarsen matter should be set for trial first.
Okay, and let's go now to Affinity, please.
Good morning, Your Honor. Is it okay if I sit?
Sure, feel free to sit. They're sitting. You can sit. Feel free.
Thank you. Joel Odou on behalf of Affinity and the real water entities. It is our position that Special Master at the hearing last Monday ordered Affinity and plaintiffs to meet and confer and draft a proposed case management order. We attempted to work out those issues during the Special Master hearing. We were unsuccessful, and that's why he ordered the meet and confer. It is our further position that we advise the Special Master that the cases could be set for trial at a minimum of 12 to 14 months. The report reflects 12 months. We believe there's more time necessary. In some of the cases, more than 200 witnesses have been listed. And so we do not believe that the case could be ready for trial in 12 months. We were asked to give that representation as to how long it would take to try the case based on what we knew. In addition, at the last Special Master hearing for the first time, plaintiffs provided their theory of liability in the case or causation in the case. That information is now 1 week old, and no party has had an opportunity to have that theory tested or have expert discovery on it. And so, again, we believe that the theory of the case in terms of the plaintiffs being exposed to vanadium, vanadium, needs to be tested. Parties need to contact experts and find out how long it will take to test concentrate, to test titanium tubes, to test real water, such that we do not believe a 12-month window is appropriate for this case. Finally, Your Honor, we would say that for this case, the Hunwarsen case, the 5 plaintiffs in this case alleged damages in excess of $400,000. Each plaintiff has approximately 8 or more treating physicians. And so for this case, and for the needs of the discovery of this case, the discovery of 9 months is completely inadequate. We again told the special master we thought 14 months. I think he picked 12 because that was a compromise between 14 and 9. But I have no other explanation as to how 12 ended up in there because I did not represent that we could get it done in 12. I said a minimum of 12 to 14, depending on once we talk to experts about the causation in this case. And so it's our position that the case is not ripe to be set for a trial, but if it is to be set for a trial, we say 14 months, simply because up until last week, we did not have a causation element alleged in any case.
Okay. But you understand, cases get set for trial when they first get filed. The complaint is from 2021, fully appreciating that it went up to federal court. But realistically, remember, your special master is only for purposes of coordinated discovery, right?
Yes, Your Honor.
You have nothing to do with trial dates. Trial dates are, in fact, you all's stipulation specifically says, right? Each of these are not appropriate for coordinated for trial, that these are unique cases that need to be set individually in the departments with each of the specific trial judges. I'm paraphrasing. I'm not doing it word for word since I'm doing it top of the head, but that's what it is. And that each of the trial judges, you know what I mean, and the length and stuff, because some of these have multiple plaintiffs, some have a single plaintiff, some have multiple plaintiffs, right? So this one has 5. This is, right? Are you saying this case in chronological order should not be first? You want
No, Your
something
Honor.
like Henry to be
No, Your
first?
Honor. We are saying because the cases have been designated complex, that should take them out of the setting them for 12 months. And they no longer schedule. Plaintiffs agreed that the cases are complex. They were designated complex. A special master was appointed to coordinate discovery. I was not counsel for Rural Water at the time the special master was first appointed, but we have had discussions about broadening the special master's authority to make recommendations on the court as to when they were ready. But the court is quite correct. Mr. Hale even conceded court on trial readiness.
Right, we tried, that's why, if you recall from the last hearing, right, a couple of months ago, court acknowledged that he didn't have it. That's why I tried to give you all as the parties an opportunity to speak among yourselves and basically come up with your, I'll call it master Excel list or whatever, you know what I mean, of how the order you wanted them and where this department's 4 cases would fall within that kind of larger master list. If you do that so that you all would have the opportunity, you being counsel, to pick the order in which you wish these cases to be tried, at least for the 4 cases here in this department. I can't speak for any of my colleagues, but also where within the global concept of all the cases where you wanted the Department 31 cases to go, right? So that's why everyone told me 60 days gave you more than enough time to do it. So that's really where we're at. I mean, that's... You
did, Your Honor, and I took the effort to contact plaintiffs' counsel, invited them to meet and confer before the special master hearing to come up with a case management order. They preferred to address it at the special master hearing. Then the special master punted it, and that's where we are today. But I confirmed in writing a request to meet and confer on a case management order with plaintiffs' counsel.
And you can appreciate, can't leave open.
That's
While
right.
they have 4 case numbers, there's over 20 parties in those combined 4 case numbers, the way I'll phrase it. A lot more than 20, but I'll just be at a low numbering, it's 20. I can't leave those left out for at some point scheduling them, because presumably you all need time to get things done. You need advance notice. I mean, the length of these trials is estimated to be a few months, depending on the number of plaintiffs and the number of defendants in each of the specific cases. So with 5 plaintiffs and the number of defendants, what do you estimate the trial length of Hunwarsen would be?
Yes, Your Honor, we agree. In fact, there's actually a total of 78 plaintiffs in the cases before the Clark County District Courts. And all cases will have to be set for trial in an order that makes sense. Certainly for this case, if this case is the first case, we think it will take several months for trial again. We were advised of plaintiffs' causation theory 8 days ago. And so the amount of experts and testing that will be necessary for that theory is still unknown, Your Honor. We have contacted our experts. They are reviewing it, but they were unable to express an opinion to us as to how long it would take to test the products. Obviously, the longer it takes to test the 3 products I mentioned, the titanium tubes, the concentrate, and the water, would also go into how long the actual trial lasts, because there would be experts talking about all 3 of those items for real water, for plaintiffs, and for the third-party cross claims, and for the other co-defendants, in addition to medical experts who would testify as to causation for the injuries. So yes.
Ballpark 4 to 6 months?
Yes, Your Honor. At least I would say.
Right now we're just focusing on Hunwarsen, if you don't
Yes, Your
mind.
Honor, I am too.
Because realizing different number of plaintiffs, different damage, and the court's taking no position on bifurcations or any of those things that we haven't even gotten close near. I'm just trying to realistically, well, parking each of these cases at even a couple of months each, got to block at that time, right? Because
Yes, Your Honor.
you let people know to get things done where they need to get done and focus on whichever case they want to focus on. And I appreciate, no way am I'm dealing with Hunwarsen, so King, don't think just because I know there's different plaintiffs' counsel there that I'm not taking you fully into consideration. It's just we're doing this case by case, okay? So,
I understand, Your Honor. Thank you.
Pardon?
I said I understand, Your Honor. Thank you.
I appreciate, yes, because I appreciate you're going to raise a different issue where you're going to be with me in trial for several months on 2 other cases. So, in any event, we'll get there. So, more than glad to just trying to find a way to get this moved forward, right? So, let's see. Any other party wish to be heard? And so that I don't have it, I'm going to do it the way you all made your appearances, right? Walk through that. Does anybody else wish to be heard to provide their information as to the timing? I mean, are you at 9 months? Are you at 12 months? Are you at 14 months? And we're focusing on this case. And also whether this case makes sense to be the first case to be tried in Department 31.
Your Honor, David Spurlock on behalf of United Foods. I have to agree completely with what Mr. Odou had just indicated to the court. When we were at the special master hearing, we anticipated there would be some discussion with regard to a case management order. At that point in time, the special master seemed somewhat reluctant and indicated that we could appear before this court with regard to providing a special case management order.
I'm talking trial dates, just so everyone's clear. I'm talking trial dates. I'm not getting into discovery dates, right? I'm talking trial dates because you can work backwards from trial dates.
Well, the trial date, as Mr. Odou indicated, I think is 14 months is very realistic. We have extensive discovery to do. Within the last couple of weeks, we were provided over 4,000 pages of additional discovery. So I think 14 months at this juncture seems realistic on behalf of United Foods.
Okay, thank you. So the next one would have been, I'll just have to, everyone's not talking at the same time. On behalf of Nevada Beverage, do you wish to be heard?
I do, Your Honor. Thank you. Colt Dodrill, Nevada Bar number 9000 for Nevada Beverage. I agree with counsel for the other defendants. 12 to 14 months of discovery is going to be necessary. The FDA conducted extensive discovery. We produced those results. The real water that was tested from Nevada Beverage inventory tested negative for toxins. It's going to take some time to track down these government employees and get them deposed, make sure we confirm their tests, and then get that information run over to our experts. So looking at 12 months at least of additional discovery.
We're not talking discovery again, counsel. Remember, the court's only talking about trial dates. The status report said trial date, 9 months for plaintiff, 12 months, and I appreciate that Mr. Odou says it was 12 to 14 months for a trial date. We're not talking about discovery time because remember, discovery time is not equal to trial date. So you're anticipating a trial date when, please?
No later than 14 months, or no sooner than 14 months.
Milwaukee Instruments, would you like to be heard?
Yes, Your Honor. I would concur with the other defendants. Trial date no earlier than 14 months.
And remember, Ms. Lowell, you can fully appreciate we need each party to name who they are each time they speak. And
I apologize. Elizabeth Lowell from Milwaukee Instruments.
Appreciate it. Thank you. Okay, do I now have local counsel on ETT1 as required under the rules?
My apologies, Your Honor. I reached out to him. Looks like there's a calendaring error. Unable to reach him at the moment. He was planning to be on, though.
Well, there is no calendaring here. This was set way. Okay, well, ETT1, I will see the court's going to have to do an order to show cause. I don't like to do those, but folks, you can't make an appearance in violation of the rule. That was a specific condition, right, of your Pro Hoc Vice application, which, folks, that firm's not just one person. But anyway, we're moving on. I can keep everybody else waiting. Okay, Hanna Instruments, do you wish to be heard?
Yes, Your Honor. Thank you. Jason Wigg, bar number 7953 on behalf of Hanna Instruments. I concur with counsel for the other defendants that trial should be set no sooner than 14 months. Thank you.
Thank you. Costco counsel, would you like to be heard?
Yes, Your Honor. Michael Federico, 5946. We believe that 18 months is a proper trial setting based upon what we thought was the agreement amongst the defendants at 12 to 14 months of just discovery. I think there may have been some interchangeable language between discovery versus trial. So our position is 18 months for the trial setting. Thank you, Your Honor.
No, trial. I thought I'd read it correctly because I was reading it straight from the bold language, but it just say trial. Okay. Anybody else wish to be heard? Hunwarsen? Okay, Counsel for Plaintiff, I do need to ask you a question in light of some of the statements that after you had an opportunity to speak about a new theory of a case being recently presented. Do you concur or have a different viewpoint on that? Because remember, the court's aware of obviously what's in complaints and all the pleadings that are filed, right, and status reports and things like that. But so that was something new that was presented at the hearing today. So can you let me know your viewpoint on that, please?
Yeah, good morning. Brianna Switzler for plaintiffs. At the special master hearing, Mr. Kemp, on plaintiffs' behalf, proposed after a titanium tube testing a theory. However, it's always been a causation in the theory that there has been some sort of toxicity in the water that has made plaintiffs sick. A specific element was named at the most recent special master hearing. Whether or not that counts as new causation, I guess, could be determined, but it's always been a theory of the case that something in the water was toxic, and the vanadium was announced at the last hearing as a result of the testing of the titanium tubes that were tested the week before.
Okay. Does that impact the 9-month estimate that plaintiffs' counsel had presented or not?
It did not. Plaintiffs' counsel at the special master hearing actually proposed a deadline of 6 to 9 months for a trial setting in the Hunwarsen matter.
Okay, so they put longer for you and shorter for, okay.
Yeah, I think he was maybe trying to...
No, yeah, no worries. A little bit of three bears here. Okay, so folks, let's get into the reality world. Reality world, I do need to set trial dates. And then what I think I can do is I set trial dates and then you all work with each other and whoever you deem appropriate to get what needs to be done prior to that trial date, right? So I'm not going to give you the discovery cutoff. I'm not going to give you a dispositive motion cutoff. I'm going to see if you're proposing something, but I think we've got to get this started somehow. And the way to get it started realistically with 2021 cases, fully appreciating that removal is going to add some timing to that, but given the amount of time that you need, given the amount of parties involved, and given the complex aspect of it, and given the fact that, in order to get you all taken care of and tried, we've got to get trial dates. And then you can address what you need to get done in that time frame. So, April. So here's where we're at. Whoever's speaking not on mute, can you please mute yourself, please? Unless, are you trying to get the court?
Yes, Your Honor. I apologize. I just was notified that our local counsel, Michael Melendez, jumped on for ETT1.
Good morning, Your Honor. Michael Melendez making an appearance.
Counsel, this hearing started at 9 o'clock.
Yes, Your Honor. I apologize for that. Mr. Kim was attending. I was traveling, and it is my fault. I apologize, Your Honor.
Right. Counsel, you do understand, right? Mr. Kim is pro hoc vice. He's only allowed pro hoc vice when you have local counsel appearance at every single hearing, every single matter, right? Straight out of Supreme Court rule.
I do, Your Honor. My apologies. It will not happen again.
Okay, and the date you filed your notice of remote appearance is when, please?
I did not do so, Your Honor. My apologies.
It was October 13, Your Honor.
Is that for you, Mr. Kim, or is that for Mr. Melendez?
It was for both of us, Your Honor.
One says, gotta move this forward, folks. This, in fairness, everybody else is patiently waiting. So, okay. That means at this juncture we have. Wait, ITT, I think you waived your right to weigh in on this particular case because if you don't have local counsel for 35 minutes and we've had the hearing, and if I now have to go hear you and circle around to everybody else, I'm going to be doubling this hearing in fairness to everybody else. I think you can hear the other ones, but not this one. ITT, do you think you need to be heard?
We do not, Your Honor.
I said ITT, I meant to say ETT, my apologies.
We do not, Your Honor.
Trying to get this case. Okay, so we're starting to go because I was starting to give you the dates, right? So, in light of what everybody has said, I have realistically, I have two choices. Does everyone agree that this case is going to take more than 2 months? Does anyone disagree? If so, let the court know. Does anyone think it's going to take less than 2 months? I'm not seeing anybody saying it's going to take. Counsel for plaintiff, your estimate of how long you think this trial is going to take 5 plaintiffs?
I'm sorry, Your Honor. I wasn't provided that information before I came to this hearing this morning. I'm sorry.
Right. But you understand today's hearing was for the trial counsel who could discuss all the trials. So I'm sure I'll be seeing you as either first or second chair at the trial, right? On all of these cases that you're in, right?
I believe, yeah, Mr. Kemp and Mr. Pepperman were in a deposition today, and I jumped in and helped out. But yes, I believe that 2 months is probably more than 2 months would be appropriate.
So, counsel, are you not trial counsel?
I am on the pleadings, Your Honor, yes.
That's a little different. I appreciate that, but that's not really the question I asked you, right, counsel? Not trying to put you on the spot, but I'm not sure when those depots were set or not. But remember, the whole purpose of today was to get everybody together after giving you 60 days to try and do it on your own, and even giving you a chance to do it with special master. If neither of those options worked, that the court was going to have to intervene and set up trials. So we needed to have parties that were fully familiar with their own trial schedules, the trial estimates for this, everything that was happening in this case, in order for this to be a fruitful meeting for everyone, right?
Yes, Your Honor.
So, do you have any idea of how much time you think this is going to take by chance, counsel?
I believe probably 2 months would be an accurate description, Your Honor, and I can reach out and see if I can get a closer deadline right now.
Did you understand, counsel, for affinity? I think you said you're closer to 5 months, right? 4 to 6 months?
Yes, Your Honor, 4 to 6 months.
That's why usually plaintiffs' counsel are about half of what defense on these type of cases. So that's why I was saying at least 2 months realistically. Okay, 5 plaintiffs, 3 months is. The reason why the court was asking that question is realistically, and counsel for King, although I'm not in the King case yet, knows this. Presently, I'm currently going to be enjoying several months. Once again, they have a difference of how many months that several months may be in a different case, i.e. the opioid cases, okay, in 2023, which overlaps some of the time that is requested for trial in this case. Once again, that's not an affirmative statement of how long that other case is going to be blocked out for, but I'm trying to make sure people actually have time in between their cases, right, to prep for different cases. Your firms might be busy on something else other than one of these few Department 31 cases. I don't know. You might have a few other things on your schedules. Maybe not, but maybe so. I presume you all do. So, realistically, that meant that if I started this trial, the earliest, taking everyone's thoughts into consideration, the nature of this case being the 5 plaintiffs and stuff, would really be starting you in November of 2023. The reason why the court was asking you all the question about if you thought it would take more than 2 months is because this court is appreciative that December may include certain time periods that certain people may be out of offices, may have family commitments, may even have travel issues getting here. Who knows, depending on where they may be coming from. So would it be an accurate assessment that no one in this case would like to be in the middle of this trial around the holiday period of the last 2 weeks of December? Or is anybody saying that they are fully available? I'll be here. I'm fine to do it. Just generally when I mention that time period, people tell me that they have other plans, and the court tries to be considerate of that. And also you might have issues with some of your jurors too during that time period. So would it be a correct assumption that parties would not like to be doing this trial in the mid to late December timeframe? Anyone thinks that they would like to be doing it, please let me know. Negatory nods or affirmative nods also work, because then I'll call on you if anybody who does an affirmative nod. Sorry, Mr. Federico, you would like to be in trial the last 2 weeks, or you're concurring that you would not like to be in trial?
Michael Federico, I agree. We would not like to be in trial during that time, especially with family commitments. Thank you, Your Honor.
Okay, that's where I was going. So realistically, putting you in November for this case doesn't seem to make a lot of sense, okay? And I'm saying that partly because I understand plaintiff's counsel, do your math, that's kind of where this would be starting, right, and getting into, so realistically, I'm looking at, I can't block out the whole month of January, realizing you still would have to do some stuff in December, folks, right? There's kind of a balance there. It's the being in trial versus the balance. So realistically, I could see starting you towards the end of January 2024. My choices realistically are either starting you in beginning of November, because I have to take into account those other cases that I mentioned, okay, and giving some time period for things that may happen, continuances that may happen in other cases on my docket. It's not just these couple of cases. So like I said, I could start you in October 2023, but then you're going to be going towards the end of this case or midway through this case at the end of December, which I don't see that anybody wishes this court to do. That means from a practical standpoint, if it's taking 2 months or more, that means I really have to put you in January 2024. That seems to meet at least counsel for the various defendants. If you do the math, that gets you realistically your 14 months for a trial date, but it also avoids the holiday time period, which I'm not hearing counsel for plaintiffs saying that they want to be doing this case in the middle of the holiday time period. So if I put you starting January 16th or 22nd, 2024 is really where I'm heading on this case. So day after, and the reason why they say the 16th is because the 15th is a holiday. And so I was thinking the 16th because that really gives you jury selection starting in a shorter week and then gets you going on trial. January 16th, 2024. Any reason not to? All the defense counsel, have taken into account your time periods, getting your time period. Plaintiff's counsel have taken into account the time period, but also taken into account that nobody's requesting to have this case be in the midst of the holiday period. You understand the court can't stop the case for 3 weeks during a holiday period. Well, good luck with your jurors on that one. So that being said, January 16th, 2024, going. Well, we're going to put you, folks. Okay. So your January 16th, 2024. I'm not doing the other dates now. We can easily get you calendar calls, pretrial conferences, etc. But I'm giving you a date so that you all, when I do status check heads up next month, you all kind of worked and made sure that we have a schedule that meets those needs, right? So that you can then back schedule all your various experts and things like that, okay? If I pick some date that somebody's aware of that is absolutely inconsistent with something in this department. No? Okay, I'm not hearing anybody say that. Okay, so January 16th, 2024 for Hunwarsen, and you all, like I said, we'll do the status check thing in a moment. Now, anything else on Hunwarsen? If not, we're moving on. Not hearing anybody or seeing anybody put anything in the chat. Okay, so next up would be, 1 second, please. Thank you so much. Okay, next would be Richt. Richt, so now we're going to call a new case number. We ready for the new case number? We're calling a new case number. Right versus 831-880, which is pages 3657 versus Affinity Lifestyles. Mr. Neale, you're here for which party, please? Are you on?
Your Honor, I am Pro Hoc Vice admitted. I'm on behalf of UNFW and Whole Foods. Mr. Spurlock is my local counsel. I'm merely observing.
Okay. It's up to you. Okay, so let's get into anybody else not being called and right yet? No. Okay, so right, as we mentioned, was 831-880, which is the second in the numeric order in this department. So to save in the right case, I'm going directly to the complaint. One moment, please. Takes a while to get through these. This complaint filed on 3/26/2021 has 4 plaintiffs, is what the court shows. Okay, so on this one, court really was intending to put it after the Hunwarsen, which really put you in the spring of 2024 in light of everything that I was thinking you were going to say, but then everything you realistically said here at the hearing today. So if anybody would like to go back to discuss all the various issues we discussed on Hunwarsen, please let me know. If not, I really was going to say, in light of everything that was said on Hunwarsen, as far as the substance of the global theories, the amount of documentation, but it being 4, not 5 plaintiffs, that this made sense to put this in the late spring around April 2024, unless somebody's requesting that I double stack these cases so that if you're not in one, you're in another. So let me hear everyone's viewpoints, and if you want a full discussion like we had in Hunwarsen, I'm more than glad to go through it all again with everyone. Just let me know what you'd like to do. And what I did not write, we do have the media, which is why I didn't ask that question when you did your appearances. Just so everyone's clear on that. Go ahead, counsel for plaintiff, please.
Brianna Switzler on behalf of plaintiffs. It's our position that trial would take no longer than 6 weeks, so that an April setting after the Hunwarsen matter would be appropriate, if not sooner.
Do you have any other discussion or any other thoughts you want to discuss? Because I'm going to go around to everybody else after you. So I'm not limiting you. You can have the same full discussion you had on Hunwarsen. I'm just, if you all want to make it quicker and efficient, we can do it that way too. What would you like to do, counsel?
As I mentioned, I think an April setting would be appropriate. If not, like I said, 4 to 6 weeks for trial setting. The documentation will be significantly overlapping from the Hunwarsen matter, and as you mentioned, there are less plaintiffs. So I believe it would be ready in that time period.
Okay, let's go to Affinity. Mr. Odou, go ahead, please.
Thank you, Your Honor. Joel Odou on behalf of the Affinity and Real Water Entities. We would incorporate all of the arguments that we set forth, or all of the issues we raised with respect to the Hunwarsen case for this case, and incorporate the same arguments. I would note that if for whatever reason the Hunwarsen case does not go as scheduled, for whatever reason, this case would take longer. And so, again, just taking this case on the merits, ignoring the fact that perhaps the court hears those issues in Hunwarsen, resolves those issues in Hunwarsen because we don't know, I would estimate trial in this case to be, again, probably 2 months to 3 months at least, possibly longer.
Couldn't I move this case up if Hunwarsen gets resolved or something? Or?
I think what we're going to do is backfill the dates. So as of this moment, yes, but once we put in the dates and talk to the experts, then I think that would be more difficult.
Okay, but the basic, is it correct, theory of the case? Well, there will be different damages, different individuals, potentially. Of course, not making any ruling. I'm just, you all have said there were different damages. So, theory of the case, the documentation, the observation on sites and things like that is going to overlap, right? So a lot of that discovery that is already coordinated.
Yes, Your Honor.
Okay, so
depositions, obviously, in one case will apply to all the cases.
For some, yeah.
With the exception of obviously treating physicians for the Richt plaintiffs as an example. That's an easy one where they wouldn't. But we agree that there is lots of cost saving and time sharing, time savings that will occur. I just note that if, again, for any reason, the other case does not go forward, this case may last longer than we think as of this moment.
But from a start date, it actually gives you more time from a start date.
Yes, it does.
And I do appreciate it. I'm looking at Department 31's cases. That's part of the reason I'm also adding an extra buffer in case you get another case that gets put in by my starting on this Hunwarsen in January. It gives chance for Ren, right, or whatever, to get in before if it's a lower case. Now I'm trying to take that into consideration too.
Thank you, Honor. We agree.
Okay, so let's circle around. Natural Foods, you're here in court. You can go first. Do you have any additional viewpoints you want to be heard on?
Your Honor, we agree with what Mr. Odou has just indicated. Our estimate of this case, considering the physicians and the medical records we've seen, was 2 to 4 months.
Okay. Nevada Beverage.
Good morning, Your Honor. Colt Dodrill, Nevada Bar 9000. We agree with defense counsel. Trial take about 2 to 4 months.
Milwaukee Instruments.
Your Honor, Elizabeth Lowell for Milwaukee Instruments. We would also agree with various defense counsel. Trial would take 2 to 4 months.
Okay. And I should circle back with Mr. Federico as well, but April 2024, is there any reason not to do it? I mean, you're requesting sooner? Ms. Lowell, sorry, on behalf of Milwaukee. April 2024, any reason not to do that date?
We have no objection to that date, Your Honor.
Thank you. Can I circle back to Costco, Mr. Federico? I should have asked you that same question, please.
Same answer, Your Honor. Thank you.
Okay,
Michael
thank you.
Federico.
Appreciate it. Okay, I don't go to ETT. I don't go to Hanna. That should take care of parties. I mean, you've also got less parties in this case. Okay. So we're going to put you... Okay. April 22nd, 2024. You all have to let the court know if by chance I happen to hit on a date that's like an accommodation date that I was not hearing. April 27th, 2024 for this trial date. Okay. Now, I'm going to, counsel, even though you have pro bonos, I'm more inclined to take King first than Henry because realistically, Henry's got a lot of parties and you all have treated that a little bit differently. Does that meet your needs? Okay, counsel for plaintiff in Henry?
Yeah. Brianna Switzler for plaintiffs, no problem with that, Your Honor.
Thank you. Anybody else have an issue if I go to King next so I keep these in numeric order? Not having anyone objecting, then let's go. Okay, so we're going to take King next. King versus Real Water, 833630, which is pages 58 to 61. New counsel, well, not new. Counsel for King, go ahead, please.
Good morning, Your Honor. Danielle Miller for Plaintiff Lisa King, bar number 9127.
Thank you.
Kihei Distributors and Kihei Distributors of Nevada.
Good morning, Your Honor. Laureen Frister on behalf of Kihei Distributors, Inc. and Kihei Distributors of Nevada, LLC.
Thank you, appreciate it. This one I also have Sunflower Farmers Markets.
Good morning, Your Honor. Dallin Knecht on behalf of Sunflower Farmers Markets and SF Markets, LLC.
Okay, we don't show, just to let you know, you're not showing on the listing of counsel on this, but okay. Let's go to, already did Brent Jones, 1 second. Instruments. Have I missed anyone on this case? This is all we show on the Odyssey. No? Okay. So, on the King matter, counsel for plaintiff, we have a different plaintiff's firm on this case. So, let's walk through just a couple of things. How much time do you think you need? And are you still at the same 9 months? Or do you think it seems to make sense to put this after the Richt case or whatever else you're going to tell the court? Go ahead, please.
Thank you, Your Honor. I think it makes sense to put this case after the Richt case, given the fact that our firm will be in trial with you for most of 2023 in the opioids case. And then we also have another trial with you in spring of 2024. So I think perhaps May 2024 would probably be best.
Okay, so let's go to, and how long do you estimate this case is going to take?
I would say 6 weeks, Your Honor, I think is a reasonable amount of time.
This is a single plaintiff case, though. Don't we think it should be shorter by the time if it's the number 3 case, it's a single plaintiff? Realizing you have a few different defendants, but less defendants than some of the other first 2?
And I thought about that, Your Honor. It's just Robert tends to try to estimate at least 2 weeks for voir dire. So I was taking that into consideration.
Court hasn't granted that, but go ahead, please.
But if I think 4 to 6 weeks would be reasonable.
Okay. Counsel for Affinity Water entities, and then also the Oasis for the King case. Counsel, please.
Thank you, Honor. Joel Odou on behalf of the Affinity entities. I left one out. Also, Real Water Tennessee LLC is a third-party defendant. This particular case, we think 2 months. The reason why is plaintiff is listed 208 witnesses in this case, plus 27 treating physicians. Obviously, some of those treating entities are pharmacies and things like that, so it's not 27 doctors, but we think 2 months for this case based on the discovery disclosed by the plaintiffs.
Okay, let's circle around to see who wants to be heard on this one. I'm going to go in court now. So, Mr. Spurlock, do you wish to be heard?
Your Honor, I would agree with Mr. Odou. We think about at least 2 months, possibly 3 months, based upon the witnesses and the treating physicians.
Mr. Spurlock, on behalf of the Whole Foods entities and natural food entities, is that correct?
Yes, Your Honor, I apologize. Bar number 2565.
Thank you. Milwaukee Instruments, do you wish to be heard?
Elizabeth Lowell from Milwaukee Instruments. We would agree with the 2 month, at least 2 months estimate.
Hanna Instruments, do you wish to be heard?
Yes, Your Honor. Thank you. Jason Wigg, bar number 7953. I concur. At least 2 months. Thank you, Your Honor.
Okay, Key Distributors, your viewpoint, please.
Laureen Frister, bar number 13217. I believe 2 to 3 months.
Why 3 months? You're the first one to say 3 months. Why 3 months?
I was trying to I was trying to agree with what I thought I heard defense counsel say, and if I heard wrong, I apologize. But we do agree with Mr. Spurlock and Mr. Odou's estimates.
1 second. Okay. And this one we had. I'll try again. Anybody for Sunflower Farmers? Oh, sorry.
Yes, Your
you are
Honor.
here, Mr. Connect. My apologies. I just didn't see
Yes,
your
Your
name. Go
Honor.
ahead, please.
We agree a minimum of 2 months in this case, given the number of witnesses.
Okay. Anybody not been heard yet on this case? Well, I am thinking May, but I'm not thinking 2 months. Well, I'll deal with that when I get to Henry. But I really am thinking. Let me circle back to. Right. If I do April. Actually, I'm thinking June. Counsel for Plaintiff, you had said May, but I'm really thinking June of 2024 in light of. I'm trying to balance cases going away, balance cases for time periods, and give you all chances in between the two to actually maybe take a breath or so.
I think that makes sense, Your Honor. June 2024.
Yeah, June 2024. Since I'm picking kind of the third weeks, it seems to me June 17th is sounding good. 2024, because 2 months, right? Which gives us some flexibility back and forth. And since I've got many of the same parties, we'll know closer to the time if we have to adjust things. So June 17th, 2024 for King. And of course, you realize there'll be holidays and all this stuff in the middle of this, which we have to carve out. But okay, so what else does anybody else wish to be heard anymore on King? Not, I'm moving on to Henry. Is case 844176, and that takes us to pages 62 to 64. with the status check on Henry. Henry, counsel for plaintiff. I'm not the bill collector, but friendly reminder, because clerk's office, they ask us to mention, this shows a filing fee balance due for additional plaintiffs. So that's just a friendly heads up that pops up onto my thing. Okay, so let's go next into, given the number of plaintiffs on this, given where it is, and given the fact that this was mentioned in the status report from the special master as having some additional, from the other 3 cases, some additional issues. Let's hear what parties' thoughts are. Go ahead, counsel for plaintiff, please.
Good morning, Your Honor. In light of the King being set in late June, we would propose that a trial setting could be set in approximately 6 weeks after that, and then our trial would only take still about 4 to 6 weeks in that matter.
Okay, so you're thinking August or September 2024, is that correct?
Looking at the calendar, yes, Your Honor, that is correct.
Okay. And you can appreciate, I'm doing these not overlapping on any dates because everything I've said previously, and also taking into account you might get other trial judges that may have different views, and so at least we're not stacking them here in case you need to stack them elsewhere. I'm trying to give you some time in between. Okay, counsel for the affinity entities et al. Go ahead.
Thank you, Your Honor. Joel Odou on behalf of the affinity entities. We would suggest September. We think a slightly longer trial. This case involves a minor with 2 parents as obviously plaintiffs in the case on behalf of the minor. And so we think it's a 2-month trial. Could be set September.
Okay. Mr. Spurlock, on behalf of all your entities, the Whole Foods, Natural Foods, etc.
Yes, Your Honor, I would agree with Mr. Odou. We have looked at this and we suggest that it's 2 to 3 months as far as the trial date.
In September 2024?
Yes, Your Honor.
Okay. Kihei Distributors of Nevada, your viewpoint, please.
Laureen Frister for Kihei Distributors of Nevada, and we would agree with defense counsel.
Okay, and if somebody doesn't want to be here, you can just say, don't need to be heard, but I'm just trying to make sure everyone gets taken care of. Milwaukee Instruments, your viewpoint, please.
Good morning, Your Honor. We would agree with the 2-month estimate and the September 2024 trial.
Bless you. Appreciate it. Thank you so very much. Okay, Hanna Instruments, please.
Jason Wigg, bar number 7953. I agree with the September trial setting. Thank you.
Thank you. SFM LLC.
Dallin Knecht, Your Honor. We'd agree with the September trial setting as well.
Okay. 2 months. Thinking inconsistent, September 16th, realistically, that company is the 3rd weeks on these. September 16, 2024 for Henry. Did I say something wrong? September 16, 2024.
No, I'm sorry, Your Honor. I'm just hard of hearing.
No worries.
I heard you the 3rd time. I apologize.
Yeah, 9/16/2024. Sorry, if you appreciate my voice. We've been talking. Okay, so that should take care of Henry. Now, what, if anything, anybody would like to address for your rest of your status check? Because Henry, we really haven't had anything else on or anything. Or does that conclude the status check? And you all have enjoyed the last hour and 15 minutes, and you've got other cases you'd like to address. But is there anything else on Henry that the court can do for you all?
Your Honor, Joel Odou on behalf of Affinity. Is the court inclined to set a status check on all of these cases? Did we miss that, or is that next?
That is going to be next.
Thank you, Your Honor.
Realistically, I wanted just to take each one of these individually, and then what I was planning on doing is I kind of gave you a heads up that I was going to be doing this in about 30 days, and it can be 30 days. It can be like 45 if you think that's going to make more sense. Realistically, I'm trying to figure out time frames between now that we're in mid-October, right? So if I say 30 days, that gets you right before the Thanksgiving holiday. If I do more like 45 or whatever, that puts you right around the Thanksgiving holiday or right after the Thanksgiving holiday. But trying to give you enough time that you can work your underlying dates in light of now that you have trial dates. So, but I was going to do all 4 cases again on the same day, unless you all are requesting that I do them on 4 separate days, 3 separate days, 2 separate days. It seems to me the 4 on that one day seemed to allow the most efficiency for you all to hear everything that was happening in the other cases. And you, other than I've got a few different counsel in a couple of the cases, it's logging on, logging off, but if you wish to, but it seemed to me that was the most efficient manner. So I'm thinking mid-November, but I could easily do the 30th December status check for all 4. So I'm going to, let's see. Let me see where I am trial-wise. A couple things on my calendar. 1 second, please. First off, does anybody want this not to be all 4 cases on the same date? Anybody want this? Anybody need their billable hours? They need me to do this on 4 different dates? I'm not hearing anyone. Okay. I mean that somewhat kiddingly, but if there's a reason to do these on different dates, I'm more than glad to do so, but someone just needs to let me know. Seemed to me the efficiency, 1 date. Does everyone agree? 1 date? I'm seeing some affirmative nods remotely.
One day would be terrific for real water, Your Honor. Thank you.
I mean, I presume you all have other things that you also need to get done. Okay. Probably don't want me to do this on the 21st. I'm thinking December 5th. Does that give everyone... December 5th still gives you enough time. See, I'm balancing with Hunwarsen. Okay. I can either see you on the 21st or December... Actually, the 28th or December 5th. So the Monday after Thanksgiving or the 1st and 5th. The only challenge I have about the 5th is I want to make sure for Hunwarsen that's not too late of a date that somebody says, guess what, we haven't seen you judge and now we can't do the trial, which I'm sure is not going to happen, but I'm amenable to the 28th or the 5th for your next status check to make sure everything's done, taken care of, and where those cases are moving. Is there a reason to do one date versus the other date? I'm going to circle around one last time, and if I get a majority saying one date, I'm going to pick it, and if it's, unless there's, you all have already scheduled a huge number of depots on the one date, and I don't yet know about that, but 28th or the 5th, counsel for plaintiff, your preference, if any.
Good morning, Brianna Switzler on behalf of plaintiffs. I believe the special master was also planning on setting his, our special master hearing on one of those 2 dates, but we just haven't received the notice of hearing yet for the special master. I know he said he was in arbitration. So plaintiffs counsel would ask for the 5th, just in case we can get the special master to look at the hearing one more time.
Okay, counsel for affinity entities.
Joel Odou on behalf of the affinity entities. I was actually looking to see if we were set for that hearing on the 5th. I don't believe a notice has gone out yet, but I had a note that the special master hearing might be on the 5th, but obviously we can move it. But we would prefer this court to set it for the 5th or later.
Okay, Whole Foods Council at all entities and natural foods.
David Spurlock on behalf of Whole Foods, bar number 2565. Your Honor, I agree with Mr. Odou. I think the special master indicated that he was going to try and schedule a hearing for December 5th since he's in arbitration in the month of November. But we have no objections to the 5th if this court wishes to set it for that date.
Okay, I'm just going to, sorry for you remote folks, okay? Because if I call it on each, so if anybody wants them to be separate hearings, you need to let me know. But I'm just going to let you all speak if you wish to speak. If anyone disagrees with the 5th, I'm going to let you speak. If I have more than one person, we'll take it in order. But to go through all your listings with each of the cases is really, seems to me, not the best use of time. But so anybody remotely have a different viewpoint than the 5th? Also for plaintiff on King, I wanted to make sure, because you're not the same plaintiff's counsel, but does that meet your needs? Doing the 3 ones that have...
Danielle Miller for plaintiff Lisa King. December 5th is perfectly fine. Thank you.
Thank you. Any other party? I don't want anyone to feel left out, so feel free to speak if you have a different viewpoint, if you want to say the 5th out loud so that you're saying it or anything. Go ahead. I'm taking silence as acquiescence because no one's turning on little green lights that tells me that you're trying to speak. Okay, so we are going to do it the 5th. I am going to do it at 8:30 on the 5th because I'm in trial, and so that way I can balance all more cases on my docket, right? So, no, you all are my most important cases right this particular moment, but I have other cases that will be my most important case. My 1 o'clock trial will be my most important case at 1 o'clock. You know how it goes. We've got broad dockets. We have to balance everyone. So that being said, December 5th, 8:30, we're going to do a status check. And what that status check is going to be, just so everyone's clear, you will be meeting and conferring before the 5th, right? Because the first, after we do appearances, right? If I don't have nice little scheduling orders, right? CMOs, however you want to call whatever proposed document you are wishing to submit to the court, either directly through the parties via stipulation, or you're asking to do it through the special master, or however you're planning on doing it, then we'll have to take the time to walk through additional dates and treat it, right? That way. I presume you all, as incredibly qualified, experienced litigators, can get that done before that date so that you can make effective use of the time, right? So that if not, I will have to help you all pick dates. I think you prefer to probably get things that meet y'all's needs. Please get together and get it done. And then we'll see what else needs to get taken care of, because between now and December, I don't know what other departments may or may not be doing. And we just want to make sure that all your cases are taken care of and you're all able to do all your cases that you need to get done. So is there anything else before I wish you all a great rest of your day and week that anybody needs on any of these cases? I'm seeing negatory nods. I'm not seeing anything from certain people, and at least one person is logged off. So with that, we're going to say thank you very much. Have a great rest of your day and week, and we'll see you. Some of you will see you tomorrow, and others will see you on your next case or whenever it may be. Thank you so much.